Welcome to the Triple D Podcast, Donuts, Disability, and Discourse, where host Michael Leiner talks to the best in the business about community, impact, business, and donuts. Here's your host, Michael Leiner.
Welcome, everybody, to an excellent episode. I'm so excited of the Triple D Podcast Bonus Bites. I have a guest today who I'm truly excited to get to spend some time getting to know better and sharing with the world. Judge Ron Waldman. Judge Waldman was a distinguished ALJ at the Social Security Administration for many years, and so he has a unique background that we don't normally get a chance to tap into. And I just want to welcome you and thank you so much for giving us your time, Judge Waldman. Tell us a little bit, give us your background. How did you end up entering the world of Social Security?
Well, it's interesting because preliminarily, after going to law school and getting an advanced law degree in LLM and trade regulation, Social Security was honestly the furthest thing from my mind. I was a consumer protection and litigation attorney for the Federal Trade Commission for 20 years. A good friend of mine in year 18 or 19 was telling me how he was exploring an opportunity as administrative law judge for Social Security, doing primarily disability hearings. And I thought, wow, that sounds interesting. And given that we were coming from similar backgrounds, I thought we might be able to make a similar adjustment. And what was interesting back then is that there had been a long freeze on bringing in new ALJs because of litigation that was going on in those years. And finally, after years of a freeze and small ALJ numbers, it opened up. So I was fortunate enough to take an exam and eventually be selected and put my career path in a totally different direction in many ways. But the one thing that remained in place, which actually meant a lot to me, is I was interacting with the public, but in a different way. And whereas at the FTC, my job was to help consumers who were victims or to help them prevent them becoming victims, my role as an ALJ was different. I had an even greater interaction with consumers, but my role wasn't per se to help them. It was to hear them and make a decision and fulfill the oath that I took when I became an ALJ.
Got it. And what year was it that you ended up becoming an ALJ finally?
It was the summer of 2008, and I stayed on board for 13 years. And right after the main part of COVID, when we had switched to hearings almost exclusively via telephone, because I had a long federal career, I thought that I might be able to go to a different part of my life. But I'm still involved in Social Security matters because I'm occasionally an online expert. And here in that role, my goal is actually only to help consumers with their Social Security questions and their disability questions when it comes up.
Now, let me ask you, when I know a lot of ALJs, their first assignment is they take it wherever they can get one. Where did you start off? Was it where you were living at the time?
Well, I was living in Long Island in the New York metro area. And so because I had still relatively young daughters at the time, it was important to me to stay in the region. And the first post that came up was in Queens, New York, which was where I grew up, and I would have been willing to accept it, and I did not get the post. And then, lucky for me, Long Island, New York came up, and that's where I lived. So I was able to ditch the hour-and-a-half Long Island Railroad commute every day to a 20-minute Long Island commute by car, and it was a big quality of life improvement as well.
So when you were working for the FTC or just in your regular career, you were commuting into the city every day.
One Bowling Green. I unfortunately was there for
Wow.
2 terrorist attacks, which were difficult moments in my life.
Sure.
And it's part of my past. And I don't know if it will come up at all, but one of the most interesting things in my judicial career is how many first responders appeared in front of me and how difficult that was for me to hear these stories. And we'll talk about judicial discretion and things like that. But if I could go out of my way to get enough information so that I could give them the fairest decision possible, I certainly wanted to go out of my way for that group of claimants.
It's interesting that you say it that way. Were there barriers to giving them the help that they needed?
That's a really good question. And the answer is yes, because even I started my career in 2008. So that was 7 years post 9/11. And as time went by, we had a lot of people who were first responders who continued with their career, whether they were NYPD or FDNY or other first responders. And many of them went back to work for significant periods of time, and then were coming to me and saying that they were disabled. And so it was difficult because I had to understand, okay, you were a first responder. This is what happened to you. You went back to work for X amount of years. Tell me what happened that now you are unable to work. Was there any event or change in circumstances that intervened? And those cases could be really difficult, particularly if there were cases where people were dealing with mental impairments. And I would have to ask, okay, were you doing okay after 9/11? What changed? What happened? And sometimes what the answer was, and it was quite difficult to hear, is, Your Honor, my friends are dying. And I had one person say to me that he was supposed to be on duty on 9/11 and had a medical appointment, and he asked a friend to sub for him. And that happened, and the attacks happened, and he went down to ground zero to help. And it's even difficult for me to say it today. He found his friend's body, and he was dealing with that survivor's guilt. And, hearings can run the gamut from really straightforward traditional issues, and then ones like this, where as a judge, you are honestly shaken to hear that type of testimony. And yet still to effectuate my role as a judge, obviously that's not enough, as you know. There had to be medical evidence and medical records to show me the impact of the 9/11 events, whether they be physical and breathing issues, COPD, PTSD, whatever they were. So yes, I had my ear, and I wanted to pay this individual, but I needed the evidence to support that because I took an oath to do that.
We got here a very different way than I expected to, but you're, telling this story about 9/11 and first responders. There were so many things that I had thought that I wanted to ask you about that this brings to light. One, mental health cases, because the standard, I believe, for being awarded Social Security disability or SSI benefits with a mental health impairment, it is so subjective, which it's in the eye of the beholder. Does the adjudicator or ALJ, they're almost given discretion to decide what they believe is a mild impairment, a moderate impairment, a marked impairment. A lot of people forget that we do have something called that's an extreme impairment. It's like people think that it ends with marked limitation, but what does the definitions for those things mean? Nothing. What's a marked impairment? Well, it means less than extreme, more than moderate. totally unhelpful. There's no checkbox, nothing objective that you can use. But also, what this brings to mind is how much weight can you give the statements that are given to you in a hearing? Because I hear, I have a very busy hearing schedule. I mean, I probably do in a typical month 40 to 50 hearings. And I hear judges say to me all the time, well, I can only consider what's written in the records. Well, then why are we here, Judge? What was the purpose of you bringing this person to testify before you if nothing that they say matters? So, um, there's just so many elements to the 9/11 first responders, that gap in time between the event, and this is common with all post-traumatic stress disorder cases, right? I mean, the triggering event, if somebody was, I hate going to, the worst, when people are subject to sexual abuse as children, but then later on as adults, they experience the trauma in different ways. It's different but similar.
There's
And
no
how do you deal with
blueprint
that?
to any of this. I mean,
No.
the judge I was in 2008 was nothing compared to the judge I was 13 years later.
Tell me about
I
that
I would
evolution.
almost make fun of that 2008 judge, because you hear so much. And listen, the testimony is, I would say, it's critical, and it is one piece of the pie, so to speak. It's an important piece because let's say you have great records and then you have very poor testimony. So, what do I do with that? Now, it could be that the records are not adequately reflecting reality, or it could be that the testimony is, I don't want to say tainted, but cast with the underlying impairment. So sometimes claimants are not good at testifying. And my job was to help them, and particularly
Thought that
mental
was my
impairment,
job.
with mental impairment cases, and in other cases as well. One of the most important things that I would do every day is to make people feel at ease. For most people, a disability hearing is the only time they will encounter the legal system in a meaningful way. Everything before that was Judge Judy-ish on television, which is fun and entertaining. I can't watch it, but it's not realistic.
Right.
So my role often, particularly in mental impairment cases, was to put someone at ease. I would give a roadmap of where we were going to go, how this was going to work, the type of questions I was going to ask, so that there weren't too many surprises. And by putting a person at ease, I get better testimony, because a lot of claimants feel that this is an adversarial proceeding, and it's not. I'm not the adversary. I am a fact finder and decision maker. And I'm not there to play gotcha, except of course every now and then there is a, wait a second, the records say A and you are saying something completely different. Help me understand. And sometimes counsel, and you may do this, would call me out before the hearing. Say, Judge, I have to tell you a couple things about my client. There are some areas that are really difficult. I'll give you one example. Attorney came over to me and said, my client is going to testify about her twin children. I said, okay, counselor. Your Honor, she doesn't have any children. And I'm like, okay, thank you for sharing that with me. I understand that this is probably part of the underlying problem. And he said, yes, Your Honor. And so we did the hearing, and she started talking about her children. And I could have said, you don't have any children. And that wasn't going to help me get to where I needed to go. So instead, I asked her questions about her children. Where are they today? You're at the hearing. And she gave me answers. And I asked some more questions. Where did they go to school? And again, at that moment, I could have said, you don't have any children, lady. But I knew that that was not going to be effective. So the hearing continued. And at some point, when I got more and more information, I said, is there anything else you want to tell me? I heard there may be some issues in terms of, your children, and maybe that's part of your issue. And eventually she looked down, she looked at me, and she said, Your Honor, I'm sorry, I don't have any children. But it was so much more effective to handle it the way I did than to confront her and say, lady, you don't have any children. It would have made her angry, it would have made her upset, and it would not have helped my goal of being a fact finder and a decision maker.
I assume that the purpose of her belief that she had children was she must have had some sort of schizophrenia or personality disorder,
Yeah,
right?
she did. She had some type of personality disorder,
Okay.
and it's important. I always like when counsel gives me the heads up,
Right.
or there are situations where, as a judge, one of the things that was least effective to me is when claimants exaggerate. And the exaggeration can be significant. And after the hearing, I would turn to my court reporter and I would say, did counsel go over testimony with their client? Because if they did, I would not have gotten such extreme testimony. One of my favorite examples is I had someone who came in and they had orthopedic issues and told me they had real difficulties lifting and carrying things. I said, okay, help me understand, what are those difficulties? Your Honor, I can't lift and carry anything. Now, anything is a difficult word to understand, and I understand people may not literally mean that. So I said to the claimant, sir, when you say you can't lift and carry anything, tell me what you mean by that. Can you lift and carry 10 pounds? No, Your Honor. Can you lift and carry 5 pounds? No, Your Honor. Can you lift and carry a pound? No, Your Honor. Can you lift and carry 8 ounces? No, Your Honor. And I go, so you're telling me you can't lift and carry anything at all ever 365 days a year? That is correct, Your Honor. And I looked at them, I said, you walked in holding a water bottle in your right hand. It's over there on the table. And so now, let's say the medical evidence is really good. I mentally am going to push back. Now, it doesn't mean at the end of the day that person doesn't get paid, but they lose their credibility on their testimony. And it makes me, judges are human beings too. We're not automatons where you input 10 things and you get certain outputs back. We're human beings. We are supposed to be neutral and fair, and that's my number one goal. But we all come to the table with our life histories. And so for me, the exaggerations really hurt a lot.
If you were to switch to the other side of the table, or now the other side of the phone, and be an attorney representing a client, and you're in that conversation, what you're having the hearing preparation conversation, right? Whether they do it a month before, a couple weeks before. We like to do ours 4 to 6 weeks before, and then have another follow-up call right before, just to make sure we're on the same page again, nothing's changed. But what would you be, and it's case by case, I'm sure, but are
Yeah.
there specific points that you would always want your client to know about how to address the judge, how not to address the judge? How can you lose somebody's attention? How can you gain their attention?
Well, one of the things, if I was, I'm going to use a baseball analogy because I'm such a big baseball fan.
All right,
One of the
batter
key
up.
things
Let's
that I
go.
think important for counsel. And I mentioned this briefly before we came on. I'm a big person on know your audience. And so what does that mean? Counsel needs to give scouting reports to their clients. So we had 8 judges in my office. I think they were all good. I think they all, including myself, had strengths and weaknesses. My goal was to put people at ease, and I think I did that really well. But you got to know who is your audience. Judge Waldman, I know he asks certain things during his hearing. All right. He may ask you, do you like music? And you may say yes. And he may ask you, who's your favorite artist? And you may say Dave Matthews, which, by the way, happened at a hearing. And Judge Waldman may ask you, given your impairments, would you go see a Dave Matthews concert in Jones Beach, Long Island? Does the judge really care that you like Dave Matthews? No.
No.
But he wants to understand how much you're able to do the things you would like to do in your perfect world. And the funny anecdote to that was, I said, would you go to a Dave Matthews concert at Jones Beach? And the client said, Judge, are you taking me? Which we had to pause for about 30 seconds of laughter. But you got to know who your audience is. For Judge Waldman, this works. For Judge Jones, that works. And so you can't prep everyone the same way for a judge. You got to know who your judge is going to be. Is he a fastball pitcher, or does he throw a curveball and a changeup? And the more counsel knew the judges, they knew their audience.
I struggle so much with these ADL questions. And the reason that I struggle is because I understand the reason that they're asked, right? The reason that they're, can you cook? Can you clean? But the real question is, could you do any of those activities 8 hours a day, 5 days a week? And I know, and listen, it sounds like you had a great office on Long Island, and
I
actually that's
did.
been my experience. I haven't had a ton of hearings with the Long Island hearing office, but judges who basically approach the law the way that I think I would if I was a judge. If you've got a good case, I'm going to find a way to approve you. If you've got a shitty case, no. But if you're in that middle third, and that's always how I kind of like to look at it, there's people in buckets. Help explain the inconsistencies that I might see. Help me understand. Give me an opportunity to argue to you as a lawyer, to a judge, why my client is disabled. And that's the purpose of a hearing. The purpose of a hearing isn't for the people who are 60-year-old construction workers who broke their back and, there's a system that's set up against them, or the people who think that they're disabled because, they've got mild asthma and they're 32. It's for the people who the record doesn't tell the full story. And how do you elicit the testimony to get them there? But I work with a lot of judges around the country now who I know when they're asking those ADL questions, they're just authoring their denial. What they're doing is, they are just setting you up. And then in the decision, they're going to say, well, you said that you prepare meals. You said that you do all these other things. And so what I try and tell my clients is, I don't care what he asks you. You can't hear what he's asking you. You've got to hear what I'm telling you, which is if he asks you, do you cook? That's not the question. The question is, how do your limitations affect your ability to cook? Because do you cook? Yeah, I've ruined every relationship that I have because I'm, a terrible, I'm a poor communicator with people and I've got a mental illness and I live alone. So how else am I going to get meals? But I have to do cooking once a month because I don't know when I'm going to feel well enough to do it again and I freeze everything. Or to me, cooking is heating something up in the microwave. But I struggle to get clients to necessarily line up with that. And I'm stuck with bad testimony a lot, that it's not a lack of preparation.
Well, see, the thing is, every judge is different.
Yeah.
I don't go or didn't go into hearings to deny cases.
Right.
I didn't ask questions for the purpose of denying the case. I'm sure there are other judges who are different. And listen, sometimes I will be candid with you. I was really good at what I did. And I'm not saying that there weren't others who were as good or even better, but I didn't have a goal to deny cases. I had a goal to understand. So the questions on cooking or household chores or going to that Dave Matthews concert, they were all little crumb trails. And if I got the best testimony in the world that was not supported by the medical evidence, I wasn't paying that person. And if I got the worst testimony in the world, but the evidence was just tremendous, I am paying that person. And sometimes you would hear surprise things. I was looking at one of the videos you posted the other day, and you're talking about the difficulty of migraine cases. And yes, they're very difficult. And, I would frequently ask the question for migraines or other impairments. By any chance, do you keep a diary? And every now and then, Judge, yes, I actually do keep a diary. I have it at home. I go, how long you've been keeping it? Judge, for 18 months. Wow. I mean, just to have that, a contemporaneous recording of symptoms on a migraine case, or for that matter, other cases. Judge, 5 days in January last month, I could not leave my home because of symptoms. It's incredibly helpful if it's consistent with the evidence. And, for a judge, one of the best paths to granting a case, if it was supported by the evidence and the testimony, was an inability to work a full-time competitive schedule. Because whatever else the record showed, if the medical evidence demonstrated that was the ticket to a fully favorable decision. And many times, there are times when I really want to pay somebody because of their story, because of who they were or are, because of the medical evidence, but sometimes it's just not quite there. And in my heart, and I still remember these people, by the way, there was someone who had genuine issues, and he went and he got a postgraduate degree. And I so wanted to pay him, and the evidence wasn't there, and I have an oath I had to fulfill. And I will tell you, there are times people came in where just their testimony and their attitude just didn't sit well with me. And after the hearing, I would say, I really didn't like that person, but it doesn't matter. They're getting paid because the evidence supports their impairments.
When you were behind the bench, did a lawyer enter your courtroom with the opportunity to change your mind about a case?
So if I'm hearing you correctly, because obviously just the way this works is this. We prepare for the hearings.
Tell me what that's like. I'm really, and I think other people would be interested in knowing what's the preparation like on your side. Who's helping you? What's going on there?
It's really interesting and fascinating because, there are weeks where we are overwhelmed. I would do hearings generally 3 days a week, every other day, Monday, Wednesday, and Friday, and have a minimum of 5 hearings, and at the most on a bad day, 7. And we often would get a preliminary summary from a staff attorney. That would be helpful. However, the attorney is not the judge. So I would review the record, highlight the things that I thought were strong, highlight the things that I thought were weak, highlight the questions I wanted to ask. And I had a script. And the script is merely a template. Because as you know, if your goal is to stick to a script, someone will say something and
Right.
you'll miss it. And earlier in my legal career, I've had depositions where people give the $1 million answer you're looking for, and you got to hear it. And so, and during a tough week for judges, we would have to allocate our time, and we would have to say, okay, I got 5 cases this day. This one looks really weak. This one has 300 pages. This one has 4,000 pages. And we would have to juggle and decide where to spend our greatest effort, with the understanding that many cases would go into post-hearing development because it was our job to have a complete record. And so, the powers that be hate that. They don't like to see, Judge, you had 15 hearings last week and 12 of them went into post-hearing development. They don't like that.
Sure.
There is a not so subtle push to have conclusions to the hearings on the day you have them. And I frankly would push back on it because, again, my oath isn't to get this done in a set time. My oath is to do timely, legally sufficient hearings. And the judges get reviewed and feedback. And, particularly in the 2 or 3 years before I retired, there was a lot of pushback. And some of it, honestly, was not welcomed by the judges, because judges, in theory, should be judicially independent.
Now you're bringing up an interesting topic. I mean, I'm just putting a timeline of events together here, and when you're talking about the changes that occurred in the last couple years of your career, that would have been the second half of the Trump administration.
Correct.
Um, and now we are entering the first days of the new Trump administration. And I know you've been uh, away from Social Security for a couple years, but based on what you saw in your time as an ALJ during the first Trump era, what would you predict, or what do you think is likely to be a push, um, inside of the agency as it pertains to disability applicants these next 4 years?
Well, candidly, I'm terrified. I have a lot of friends, judges, who are with SSA now. I've been talking to them very recently, including yesterday. And some subtle things are already happening that I'm concerned about. And, as a judge, I'm fully committed to the judges being fully independent. As you know, and I know you posted something about it today, most federal employees apparently are going to be asked to come back to the office. This is
Right.
a dramatic change. It doesn't necessarily mean that claimants have to come back to the office, particularly where there's a need, difficulty getting to an office. In and of itself, I will be candid with you. I liked in-person hearings because during the height of COVID, it was all telephonic. And pre-COVID, there were some video hearings. And I will tell you, you lose something on the telephone. I cannot tell you how many times I had hearings where I went on the record to point something out. because if I don't point it out, it never happened. So, for example, I might say, counselor, I just want to note for the record that when your client walked into the hearing room, their brother had to help them get into the chair, and it was quite difficult for them to do that. If I don't say that, it never happened. And I did it on video hearings too, and sometimes counsel were shocked that I was saying it, because that's our job. And to the extent that this video and other videos are being shared with potential claimants, to me, the most important takeaway that they can have is the judges are there to hear your case and story. They are not there to deny your case. They're not there to approve your case. They're there to do what's right. And my goal in every hearing was, when that claimant left the hearing, whether or not I ultimately paid them or denied them, I wanted them to know I was heard. This judge cared about what I was going through, because whether or not a person is disabled or not, 99% of them were dealing with real world issues. Maybe they didn't qualify for disability, but these are human beings and people. And I don't want them to come away from the hearing, even if I denied them or paid them, and like, what, did the judge have a lunch appointment? He asked me nothing. He didn't hear me. He didn't give me a chance. I haven't done my job. And getting back to the original question, I am unfortunately very concerned about what will happen during the next 4 years. I felt there was an anti-judicial sentiment. It did filter down to me. I will tell you candidly, and I have told others, there was pressure on me to deny cases. And I pushed back against that as hard as I could, because of the oath that I took, and there's nothing more important to me than that. And towards the end of the Trump administration, I didn't know which way the winds were going to blow, and I decided that, I had the advantage of maybe doing other things in my life, including retiring. And when the election went to the Democrats, I said things will probably change and I can stay. I decided to leave, but I will tell you firsthand that things did change. And, judges are more productive when they are not getting pushback from within their office or within their region. A judge who feels they're being supported on many levels is going to be a better judge. And I am hopeful that things will be good, but I'm not optimistic.
So, I mean, the one thing that stands out that I heard you say is you have a fear that there's going to be a push for judges to deny more cases. How is that done? How do they, I mean, there's little subtle things that they can do, like, for example, taking away the treating source rule. There's, little changes that they can make periodically to the listings, but what are the pressures that they would put on an individual judge? You can say from experience or hypothetically, but where does it come from?
Every
No.
judge is like a baseball player. There are statistics. Someone could look up the back of my baseball card, even right now, and I haven't been doing it for almost 4 years. And there is the data is there. What cases, the percentage of cases do they pay? Then we have, appeal agree rates and things like that. And we're human. We don't like cases coming back on an appeals council remand. We don't like federal court cases coming back. Every now and then, one of my judge buddies say, "Hey, Judge Waldman, I just got one of your cases from 4 years ago." So the numbers are there. And I note the number. I had a higher pay rate than most judges. And in my heart, what did I think about that? Didn't care. Because I know what my point of view was. I know what my oath was. But I can't tell you that I wasn't concerned that the number may go up. And during this time period, informally, I was called in to speak to the regional chief judge and to my chief judge. And I thought they would kind of beat around the bush a little bit. And I was shocked. They didn't. They came out and said, "You're paying too many cases." And I was shocked at the approach that they didn't take, which would have been, "Judge Waldman, we've looked at your decisions, and yes, we think you're a good judge, but we think this is what you could do better." And I'm a big believer we can all do better at what we do. And what I alluded to before, the judge I was in 2021 is 10 times the judge I was in 2008. I was just much better at what I did. And I will tell you that the metaphor that I used is I felt I was being asked to put my thumb on the scale, and I resented it.
Did they suggest ways that you could deny more cases? I mean, my response, if somebody were to say something like that to me, would be, well, then you need to send me more of the bad ones. But at the end of the day, if your job is to find truth, it's luck of the draw. I'm sorry. But I mean, did they offer suggestions for how you could be denying more cases? I mean,
well, what they did is they would talk about one or two cases that they said, "Well, we looked at this, Judge Waldman. In hindsight, maybe you should have done this and that." The interesting thing about that was, before they spoke to me, I said, "Do you think if there's any cases that you would like to talk about, you could share them with me ahead of time so I could look at them and better understand any questions or concerns you had?"
sure.
And if it was truly a process aimed at making me the best judge I could be, the answer would have been, of course.
Yes.
That's not what the answer was. The answer was no.
And I'm assuming that same chief judge wasn't calling into his office the judges who were approving 10% of claimants and saying, you're not paying enough.
No. They called me and my close friend, and who had the same rate. And they didn't call anyone with lower pay rates. And I will tell you what I was told that I cannot confirm was true. So, but I once did get a call from the member of the press saying this is the rumor. And again, it's important to understand that I still cannot confirm this was true.
Okay.
But I was told that within the Trump administration, there was an edict to terminate and fire the judges who had higher pay rates. And that they were told that in this civil service system, you cannot do that. So I don't know if it's true. But there was great anti-judicial sentiment on many levels, not just the ALJ level. And it was difficult for me to deal with because on the toughest cases for a judge, there are toss-up cases. Sure. There are cases that can go either way, and sometimes the inability to complete a full work schedule could be the tipping point where, for example, the 45-year-old police officer or teacher, who I think can generally do what we refer to as sedentary work, i.e. a desk job, I have an easy path to deny that case. Now, where can I go with it if I thought, gee, I really think this person's going to have a difficult time, is if I can be convinced by the testimony and the evidence that this person will be out of work 3 days a month or will have undue work interruptions. And I can hear that by the testimony or the records or the fact that they live alone and they need someone to come into the home to help them. So there's my ticket to pay a case that otherwise I might be pushed to deny. But on those close cases, I had a dilemma now. I had someone whispering in my ear, Judge, and in my other ear, Judge Waldman, you took an oath. And we're all human beings. We had to, it was in front of us.
Yeah. So I'm representing this 45-year-old who has back problems, knee problems, and I come to you for the hearing. What can I do at the outset of representation as well as even in a hearing to help you visualize that this person is going to be absent from their sedentary job or not able to, remain on pace or to be productive enough over a 40-hour work week to get you to add that into an RFC?
I need to understand how the symptoms of the condition, for example, cannot be anticipated or planned for. That's really helpful. And every now and then, I might have a hearing where I could see in the claimant's face they were struggling. Mr. Jones, you seem like you're struggling. Would it be helpful to take a 5-minute break? Come back. Mr. Jones, you seem like you were in pain and discomfort just now. How often does that happen? Well, Judge, it happens X amount of times per week. And is it predictable in any meaningful way? Sometimes the answer could be, well, Judge, the mornings are really bad. Or after there's no one to help me take out the garbage, and it's not, I don't make a lot of garbage, but I have to call my neighbor in to do it. So something that helps us understand the symptoms, the unpredictability of it, and then that those symptoms are supported by the medical evidence. And now I have the thread to tie it all together. And those are the cases where the counsel lays the roadmap for me. And again, pre-hearing memorandums can either be really good or really bad. So if counsel lays the roadmap for me, for example, Your Honor, here are the conditions, here are the symptoms. We don't think that our client can perform even sedentary work. However, even if you were to conclude that, there would be so many work disruptions and absenteeism that they could not do full-time competitive work. And as you know, such groundwork would be the foundation for vocational expert testimony, that there are no jobs where we have absenteeism of X amount or unscheduled breaks. And, that was, as judges, we also know our term is residual functional capacity. What can you do? How often can you do it? And we, more often than not, at the end of the hearing, when we usually go to the vocational experts, we know what the answer is going to be.
Sure.
We know that if I say someone can lift and carry 10 pounds occasionally, sit frequently, etc., and they're 45 years old, we know what the answer is going to be. And then we ask often the follow-up question, well, if that same hypothetical person was out 3 days a month or would miss so many hours a day because they had to take their medication and there were side effects of the medication. Now I have that path because, as you know, the goal for you as counsel and for me, if I want to pay the case, is to get the vocational expert to say either, Judge, there are no jobs, or that the jobs and the different types of jobs are so small that it means I have to find the claimant disabled.
What are the missed limitations that you've found people did not talk about or argue? Like, you know, what you're talking about, absenteeism, time off task. I call those the potted plant questions, right? I
Okay.
mean, I'm gonna call out my own profession. I would say most attorneys that I've interacted with that do this work, especially the ones who dabble in it, they just shouldn't be doing it. They don't understand the nuances, but they know enough to, when you only ask that sedentary hypothetical, to at least not sound too stupid to the client, say, well, what about if they're off task, 20% of the time? But things like leg elevation, things like manipulative limitations. How do you quantify those things? Like, I struggle a lot with the difference between, when somebody has, cervical stenosis or carpal tunnel syndrome. It's so easy for, that when you ask frequent reaching, handling, and fingering, you're going to get the entire world of work. When you say occasional, you're not. But all of these percentages don't mean anything. They're ranges: 0 to
Their ranges
33,
and it,
33 to 66. What about, but it's a farce, because when somebody can only perform those manipulative activities for 50% of the time, which is frequent, they can't do the work. So how do you demonstrate
it,
that what doctors aren't documenting?
it's really hard. Listen, the judges know that often these, we call them residual functional capacities, what a person can or can't do. It's we often chuckle to ourselves that it's almost fictional,
All
because
fictional.
to discern the difference between, sometimes between frequent, occasional, is almost impossible. And then to now take that to the vocational expert and ask them to do the same thing. And so, you do get into a situation where we have set ourselves up. Remember this, that for many hearings, when the hearing is over, the judge doesn't know what their decision is going to be.
Yeah.
What I did after a hearing where it was going to go into post-hearing development. Remember, I held maybe 5,000 hearings. It's hard to remember them. Now, yes, we have audio recordings and we can go back. But after each hearing where I was not making a decision right then and there, I'm putting down my thoughts, which way I was leaning. If I get this evidence, I'm here. If I don't get this evidence, I'm not there. But a lot of it is just the totality of everything. And sometimes the judges make things fit because we have to decide if reaching is not at all, or frequent, or occasional. And how do we differentiate between frequent and occasional? Is it based on testimony alone? Is it based on the medical source statement, which can be gold to judges? And because if they're good and they're supported by the record, maybe you get an on the record. That is to say, a decision without a hearing. And I love medical source statements, except when they're just checked boxes. And I have no idea how the doctor reached this conclusion. And there were a couple of times where I put counsel on the spot. Do we call your doctor? Well, do we call them now, or we'll have another hearing? I need to understand what the doctor's talking about here. And it doesn't make any sense to me. But I want to give the doctor a chance to explain. Or I want to understand, rather than the typical reasons that people are off task. Oh, you have a medication with known side effects. Share with me what the side effects are. Your Honor, here are the known side effects of this medication. My client will testify, and the record will show that he has these side effects 85% of the time. The ability to give the roadmap to the judge and to bring him on board your ship is the way to get the decision that counsel wants. And sometimes that happens, and sometimes I get pushed overboard. So,
I mean, there's just so many different thoughts that I have when I hear you talk, but it kind of comes back to what we were saying earlier, moderate, marked, occasional, frequent. The difference is, does the judge feel persuaded to pay the case or not? Because if they do, then it's occasional manipulative limits. It's a marked limitation. If they don't, it's frequent and it's moderate.
we are
And
looking at ways to give a final decision. And sometimes I really want to pay the case. And again, I still remember this person. I so much wanted to pay him, and I could not. And so it's just helpful to lay out that roadmap. And if during the hearing counsel discovers something that, wait a second, there is this other issue here. And judge, now that I'm hearing it from my client, I think we need to develop this more because this will add another theory to my case. And I'm going to say yes every time on the first hearing. Were there such scenarios where we had multiple hearings and I would grow impatient? Sure. It's not, we need finality. And we do get pressure. Judge, this case has been on your docket for 10 months. And finality is important to the agency because their motto in theory is quick, legally sufficient decisions. When I first started, things were different. It was all about the numbers. Numbers. In 2008, Judge, how many cases did you have? Oh, you had 60 cases this month? Great. Numbers. And then it changed. And they cared less about the numbers and more about the quality of the decisions, which is clearly a good thing.
it's just, quality of the decision is in the eye of the beholder. It depends on which way they view this system as a whole. And that's where I just find so many gaps. I mean, I graduated law school in 2010. The first job that I ever had was basically like getting the Social Security Department started for, it was the biggest workers' compensation firm in Ohio. And across the country, 2011, 2012, I don't know if you remember those years, that was when, at least in our in Cleveland, Ohio, the numbers changed incredibly in terms of approval rates in the hearing office. The hearing office in Cleveland, Ohio, and Akron, which are the two offices that I used to mostly practice between me, now we're nationwide, pretty evenly distributed. But back then, if you go back to 2008, 2009, the judges were all approving 70 something percent of the cases that they looked at. 2012 comes and suddenly it's about 30%. Same judges, half the approvals. And those were the years when I started off doing this, and I had to figure out how am I going to get my clients across the finish line? So my tactic was, how do I leave banana peels on the ground for the judge to trip on? You might hate hearing that, but I'm just being transparent with you.
I
Um,
understand it.
and time has kind of eased me up with some judges to a degree. I'm presently in an, if I were to still call like the Cleveland hearing office my home office, we do have more cases there than any other part of the country. We have judges that are back to approving 75% of the cases that they're seeing. We have two judges who approve one of them's in the five lowest in the entire country. She approves about 9% of the cases that she looks at. You better believe I am just going into every hearing with her, getting the case ready for appeal.
Because that's your
Um,
job. I mean, your
because it's
job
my
is
job.
to represent
It's
your
my
client's
job.
interests as best as possible.
I had a hearing with this is back when we were in person. And I remember she's just going, the ADL checklist that we were talking about earlier. She's so friendly to your face too. She makes you feel heard. That's the worst part of the whole thing.
Right, but it's
Um,
disingenuous.
it's totally disingenuous. And I prepare all my clients for that, but she's just going through and I was getting frustrated. So I just started whispering something into the microphone that was in front of us that we used to have in person in the hearing room. And she goes, um, counsel, what are you whispering? And I go, oh, I'm talking to the federal court magistrate that's going to listen to this transcript in a year and a half. I'm making sure they hear me telling them that even though that you're asking these questions, my client can't actually do it 40 hours per week. And the point was I wanted her to know what I'm doing. I will see you again in 2 years, and then I'll see you in 4 years, but I'm waiting until I get the judge down the hall because you can't lawfully deny 90% or more of the people who come in here. That's ridiculous.
Well,
She's not seeing different.
because to me, and this was the word used towards me that I found offensive, but here it's the other way. To me, if you're doing 90% of anything, you have an agenda. You're not fulfilling your oath.
Right.
I was asked if I had an agenda, and I was horrified by it. Horrified. And so, to me, there's just no way you can fully and fairly be denying 90% of the cases because it doesn't, the math doesn't add up.
Yeah. I don't agree with the judges who approve 90%. I'm not going to be the one who waves my arms saying, hey, we need to
Right.
change this. They're paying too much. Why? Because I've got a family to feed, right? I'll, I'll,
Listen,
I'll say that very transparent. But at the same time, I don't agree with their philosophy. I think that if you're my client, 100% of them are disabled. But looking at the program and we have different standards for the clients that we accept than pretty much every other law firm, and we're very selective about the cases that we take on. But I think that when judges are approving 65% of the cases that they look at, that's reasonable to me. That makes sense. Just thinking about the world of people that are going through this process and the evidence needing to be there. You've said something earlier that it sticks with me. Winning your disability case, it's not about what's actually wrong with you. It's about what I can prove is wrong with you. And it's not proof through testimony. It's not proof through function reports. It's in your medical records. It's got to be there. If it's not there, you don't have what you need as a judge to help that person. But um, that's that's where, people don't all have the same access to healthcare too.
they,
Unfortunately, there's a lot of people with very serious problems who are stuck seeing PCPs because they live in the middle of the field in Kansas that are going to have bad records.
I spoke to a woman the other day in my capacity as a Social Security expert, and she's 64 years old. She had a horrible car accident in 2016. She had rods in her leg, and she struggled. She pushed herself to work as a server, and she just couldn't do it anymore. And and she was over 60, and I'm thinking immediately, well, this sounds pretty strong to me. Are you undergoing, any treatment, or you've had any evaluations in the last year or two? And she said, no. Now, in
Yeah.
my heart, I thought she was disabled. But I said, based on what you're telling me, I cannot recommend that you can apply. I think you will be denied because you don't have any contemporaneous medical evidence. You need something that brings those rods in your leg. That's a fact. That's never changing. But you need to make that current, that you've had an evaluation by an orthopedist. And I said, I think if you get that done, your case now becomes an easy disability case. But people don't usually go through their life saying, what do I need to do to be found disabled? They go to life, what do I need to do to live my life? And then every now and then someone says, have you thought of disability? And a light bulb like, no, explain it to me.
See, I struggle because so many of my clients will say to me, like, well, what should I be telling the doctor so that my case gets approved? You're thinking about it the wrong way. You should be going to your doctors telling them what's wrong with you because you want to get better, not because you are trying to get disability benefits. If you're treating for the purpose of restorative health, your doctor's going to be listening more. Two, they're going to be trying different things to help you. In order to get better, you have to be more open, transparent. That's the person who's keeping that, 18-month long migraine diary, right? Because you don't do that for your disability case. You'll give up after 15 days. You do it because you're tracking it to take it to your doctor so that you can say, hey, this medication is not working. What can we do? Do I need to try an injection? Do I need to have, some sort of infusion? What is this going to take to help me live my life? I struggle when people are so focused on what do I need to do for my disability case?
But at the same time, I have told people when I say, a medical opinion from your doctor would help, that at the same time, I don't think there's anything wrong if you have a genuine interaction that goes like this. Doctor, I really would love to get back to work. I need money in some capacity. You know what I'm dealing with. You know my symptoms. You know the medications I'm taking. Do you think I'm being realistic with that? Do you think I, in the next 6 or 8 months, can go back to work? And so the opinion in that context can be very enlightening that, the doctor has seen the fact that the condition manifests itself in an unpredictable manner. And that's the basis for being off task or not working. So in that way, it's not, doctor, give me this because I need it for disability. Tell me what my path is.
I hear you. This has all been excellent, Judge Waldman. I really appreciate you taking time out of your less busy than it was, but busy
Yeah,
schedule to
thank you.
talk to us. I think that people are really going to benefit from hearing this from you. So many of the things that you said today are things that I'm trying to repeat to my clients or share on social media where there's a significant following. But I think that coming from you will really link it together in a much more powerful way. So, not just on behalf of myself, but on behalf of anybody who's going through this process. Thank you so much.
It,
Um,
it's my pleasure. And if I could have one takeaway from potential clients or actual clients, would be the notion like, that was a judge. Oh, he's a human being. To take that aura and cast away that, wait, they really care about what's going on. And as I mentioned, as a judge, I also felt my role unwritten was as a therapist too, to make people feel that I'm not against them, that I recognize you have real problems. And if I could say something in a hearing that could make someone's life better, I did. And I once gave a homework assignment to someone who was suffering from uh, horrific anxiety issues and really wanted to die. And I asked them if they had ever seen a movie. And I told them the movie, which happens to be my favorite movie. It's A Wonderful Life. They had never seen it. And because this person had said they thought the world would be a better place if they were in it. I said, I'm giving you a homework assignment. please go watch that movie, because it's about someone who's so disillusioned he thinks the world would be better if he had never been in it. And I want you to go to the library and take that movie out. That is not in my judicial job description. And I don't know if, in fact, she did it, but I'm hoping she did. And though it happened very infrequently, I do have at home the 6 or 7 people who wrote me a letter saying, Judge, you believed in me when no one else did, and I will remember it for the rest of my life. I kept that letter because it touched me. And again, I didn't do it to get the letter. But I'm hoping the biggest takeaway from people watching this is the judges are human beings, and they're there again, but every judge is different. But we do want to hear the story, and we do care.
For now, they are all human beings. That part is very much true. But
thank you very much.
Under this Doge era that we're entering, who knows if it's going to be, Judge Wally the robot going forward. I certainly hope not. But
and afterwards, I'm going to ask you about one judge, whether you've been before them, because they're one of my best friends from my Federal Trade Commission days. So I'll be curious if you have any experiences. So,
all right. Well, I'll end our recording now, but we'll regroup and you can name names. How's that?
Sounds good. Thank you so much.
Thanks for listening to the Triple D Podcast, Donuts, Disability, and Discourse. Rate, subscribe, and tune in next week for more discourse and donuts.